The concept of reciprocity of harms is an important one to understanding a lot of property law doctrines. So as a hypothetical, imagine two neighbors. They both are using their properties as residences, and one of the neighbors decides that what they really want to do is open up a coffee shop. And the other neighbor objects. They don't like the smell, they don't like the idea of the foot traffic. And the natural thing for the objecting neighbor to do if they want to make a case out of it is to bring a nuisance suit. And a principle of nuisance law is that you shouldn't use your property in a way to harm the interest of other property owners. But in this case, I think it brings out very clearly the question of who is harming whom. Now, saying, on the one hand, we can say that the person who wants to open up the coffee shop is harming the neighbor, right? Annoying them with foot traffic, street traffic, the smell of roasting coffee beans, goodness knows what. But from a different point of view, the neighbor who is objecting is harming the one who wants to open up the coffee shop. And we're assuming, of course, that under local zoning laws and that sort of thing, the neighbor who wants to open up the coffee shop is following the letter of the law. And so saying that one neighbor is harming the other is masking a contestable question of distribution. Who should have the right to frustrate the other party? And this is a general problem of conflicting land use. An entrepreneur wants to use the property as a business, unaffected by their neighbor's residence and therefore objections, and the neighbor wants to use their property as a residence, unaffected by the entrepreneur's commerce. The question of ownership doesn't answer the question at all, nor does the question of harm. The harms here are reciprocal, and the law simply has to decide who has the right to annoy the other. And so, of course, you can describe many everyday property cases through the perspective of reciprocity of harm. We talked in an earlier video about the case of Jacques versus Steenberg Homes, where the mobile home company willfully trespasses across the Jacques' land. And so, as I said in an earlier video, we could look at this as a problem of reciprocity of harms. Maybe by refusing entry, the Jacques are causing harm to Steenberg Homes. But no one would describe the case in this way because the right has already been allocated. That is, we have a law of trespass, and Steenberg Homes was willfully trespassing, and so we already have an allocation of the right. The Jacques have the right to annoy Steenberg Homes. They have a right to say no. The coffee shop example is harder because we are in the realm of nuisance. Both property owners have a right to their land. And that's what makes the case of State versus Shack that we talked about earlier so interesting. It looks like a trespass. It looks like a situation where the property right has already been allocated. The aid workers trespass onto the property of the farmer so they can provide services to migrant farm workers on the premises. And the court says there is no trespass because that would be using the property rights to harm the interests of the migrant workers on the property. And that's what's so interesting about that case. It looks like a trespass, but the court invokes the nuisance law principle of not using your property rights to harm the interests of other people. And there's interesting questions that we talked about in the earlier video of what precisely is the court doing? Is it recognizing an existing allocation of rights? That is, that the farmer's property rights never included the right to exclude the aid workers? Or is this an active reallocation of wealth, power, property rights? The court is actually changing what the allocation is? Or is it a situation in which the scope of the property owner's rights were indeterminate in the first place, and the court is now making clear a line that was unclear before? However we describe what happens in Shack, however we describe what happens in Jacques versus Steenberg Homes, the principle of saying don't harm doesn't tell us anything. There's something else behind the assessment that one party is the one who's doing the harm. There is still a reciprocity of harm. And so what I think is worth taking away from that is the value of trying to think deeply about a court's stated principle of resolution. Trying to look behind the stated principle is a big part of analyzing cases. both for understanding what the actual true holding of a case is, but also for understanding its likely scope or possible ways that courts may distinguish a holding in the future.